Welcome to Let's Brief It, a podcast by the DC Bar Law student community where we break down the law and explore how it shapes our lives. I'm Amanda Hitchez, a third-year law student and president of the Student Bar Association at the George Washington University Law School.
And I'm Sade Ajayi, a second-year law student at Howard University School of Law. Today, we're talking about the Supreme Court's Birthright citizenship case, Trump v. Barbara, and what it would mean for the 14th Amendment.
Joining us is Leon Rodriguez, an immigration partner at Seyfarth Shaw and former director of the U.S. Citizenship and Immigration Services, former director of the HHS Office for Civil Rights, a former deputy assistant attorney general at the Department of Justice, and the former county attorney of Montgomery County, Maryland. We're also joined by Wendy Feng, senior counsel at Seyfarth Shaw and counsel of record on the amicus brief submitted by the U.S. Supreme Court on behalf of the National Asian Pacific American Bar Association and a coalition of its affiliated organizations in support of respondents in this case, Trump v. Barbara. Thank you both for being here.
Great to be here.
Likewise.
Okay, let's start broad. When people hear birthright citizenship, they think it's simple, but clearly this case does not show that. So can you walk us through what the court is actually being asked to decide in Trump v. Barbara?
Yeah, so the issue in this case, simply put, is birthright citizenship. And most people, when they hear the term birthright citizenship, they have a sense of what that means. Most people interpret that to mean if you're born in the United States, you are a U.S. citizen. And that's based out of the Citizenship Clause of the 14th Amendment, which says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. What's at issue in this case is a specific executive order that was passed by this administration in January of 2025, Executive Order 14160. And what that executive order seeks to do is to limit birthright citizenship to only certain categories of people, or rather to exclude certain categories of people from birthright. And what it effectively does, and we can get more into this, is that it limits birthright to the children of either U.S. citizens or legal permanent residents.
And how has the term subject to the jurisdiction thereof been interpreted in the past, specifically in how the court interpreted Wong Kim Ark?
Yeah, so traditionally, the language of the 14th Amendment has been interpreted to just refer to anyone born on U.S. soil, with very limited exceptions. The landmark case Wong Kim Ark in 1898 specifically addressed this issue. That case was addressing the child of Chinese migrants who was born in San Francisco. And there, the court addressed the argument that birthright citizenship may be limited to certain categories of people. And the U.S. Supreme Court in 1898 said, no, this applies to essentially anyone who is born here. That is at least how the precedent has been interpreted for the last 120 some years. But what the court is being asked to do here is to sort of reframe that interpretation in light of the executive order.
Did the court in Wong Kim Ark set out the subject to jurisdiction thereof as an exception for diplomats, or is that new rhetoric that the court is considering, or maybe from precedent after the fact in regards to the executive order?
Yeah, so I think that exception has always sort of been there, and it was, the subject to the jurisdiction thereof is an exception that is written into the 14th Amendment. In Wong Kim Ark, the court sort of addressed this in the context of some specific categories. It wasn't, at the time, the concept of, political diplomats was not quite the same, but it would extend to certain exceptions.
Yeah, as I understand it, the 2K, it's actually exactly what you said, Wendy. It's children of diplomats in the U.S. under diplomatic visas, and then basically children, which is not something that it's easy to picture happening, but children of a foreign army, the soldiers in a foreign army that has invaded the U.S. Those are the two categories that have been historically understood as exceptions to what is otherwise a pretty broad recognition of U.S. citizenship for anybody born on U.S. soil.
So what is the government's position on how the 14th Amendment should be interpreted? What is the government's position on how Wong Kim Ark should be interpreted? Is the government's argument trying to reinterpret this precedent, or is it effectively asking the court to overturn it without saying that directly?
So that's an interesting question. At oral argument, the government's attorney specifically said, we're not asking you to overturn Wong Kim Ark. What they've stated is that they believe their position is consistent with the holding in Wong Kim Ark, but the holding they are asking for is for the court to essentially now interpret Wong Kim Ark differently from how it's been interpreted for the last 120 some years. The government's position is essentially that the term subject to the jurisdiction thereof limits birthright and the citizenship clause to the children of U.S. citizens and legal permanent residents, essentially people with intent to remain in the U.S. Specifically, they point to language in Wong Kim Ark and the stipulated facts in Wong Kim Ark, whereby the court says his parents were domiciled in the United States. And they refer to that language and interpret it to mean that the court upheld Wong Kim Ark's citizenship only because his parents were domiciled in the US and therefore analogous to legal permanent residents.
Shifting to the executive side, as Wendy noted, this is coming out of Executive Order 14160. Leon, in plain terms, what does that order try to change about how citizenship is granted at birth? Is it vague, or does it clearly now establish a new baseline for what is required to become a U.S. citizen?
Yeah, I don't think it's vague by its terms. What is going to be involved in actually implementing the executive order is still extremely unclear. But what the order directs is that no executive agency can issue a document that recognizes as a U.S. citizen anybody who is not the child of at least one parent who is either a legal permanent resident of the United States or a citizen. Meaning that somebody who is either the child of undocumented parents, the child of parents who are here on temporary visas, such as employment-based visas or various kinds of humanitarian relief that people may receive, that child would not be recognized as a U.S. citizen, and that no federal agency will document that child as a U.S. citizen. So the most obvious example of that is a passport. No such child at the time of their birth or at any point in the remainder of their lives would be issued a U.S. passport. But there are many other kinds of documentation that the federal government may issue that recognizes citizenship. So, for example, if there's a federal job that requires its holder to be a U.S. citizen, as many federal jobs do, then the issuance of any paperwork documenting that person as a U.S. citizen for a federal job is prohibited under this executive order. If somebody is eligible as a U.S. citizen for public benefits that are federally funded, then any documentation to implement that benefit is prohibited under this order. And then the other thing that the order says is that they will not recognize any state or local documentation purporting to recognize U.S. citizenship. That's a big deal because that means in particular that birth certificates will no longer be accepted as automatic evidence of U.S. citizenship. So there's a lot in there that's clear, but there's a lot that still sort of would need to be fleshed out if this actually is allowed to go forward by the Supreme Court.
So, practically speaking, Leon, if an agency like the United States Citizenship and Immigration Services had to implement that, what would the change look like on the ground for families and for adjudicators?
Well, it's going to mean a bunch of things on the ground. One, it means that a large number of children who could start being born the day after the Supreme Court issues a decision, if it actually upholds the executive order, would essentially become stateless and have no status in the United States. Now, to be clear, most countries have provisions for children of their nationals to be registered as citizens of those countries, even if they're born overseas. There's a couple of interesting limitations because there are certain countries that only recognize that if it is in the case of the father petitioning on behalf of the child. So if the father is unavailable, there's actually no mechanism. This is a small handful of countries, but the parents need to be able to access those mechanisms from their countries in order to record them as citizens of the parent's country. So that's one issue. The second issue is that there really is no legal framework existing under U.S. law to record a US born child as having any status in the United States of any kind. In theory, such a law could be passed that would say that if a child is born in the United States, parents would need to record that birth and that child would be given some status derivative of whatever status their parents have. But none of that is in place. And there's no representation has been made by the administration as to how any of those things would occur, which would then leave USCIS in potentially a bit of a crisis to figure out how it is going to, in particular, address the situation of children of visa holders. So somebody who's here on a work visa, whether they're working at a high-tech company or they're working at a landscaping company or doing biomedical research, there's no mechanism right now, and there's none that anybody's really talked about as to what the US status of those children will be if this executive order goes into effect.
And what communities do you think will feel the most immediate impact if this interpretation is adopted and it must be implemented per the considerations that you already noted?
I mean, clearly undocumented communities will feel immediate impact. And this is also a place to put sort of in parentheses the question of Plyler v. Doe, which is a Supreme Court decision that recognized the obligation of state governments to provide public education to children of undocumented parents. And so the interplay between this decision and the decision in Plyler v. Doe and whether that decision now is subject to reversal could become sort of the next shoe to drop in what's happening here. But clearly for those families, the status of those children becomes a big issue. But the other is that families who are here on various kinds of either visas or other sorts of permissions to be in the United States. So, again, I gave the example of families who are here on work visas. That's a lot of people at this point. Just to give the example, I think the number of people under the H-1B visa, which is sort of the standard high-skilled non-immigrant visa to the US, that's 1 million people right there whose children now potentially are affected by this order without there being a roadmap for what's going to be done for those children if this goes into effect. There's a lot of other examples, people who are have been granted asylum but do not yet have green cards or have been admitted to the US as refugees but don't yet have their green cards. Those children as well could end up as functionally stateless at this point because there's no mechanism to do anything else with them the way this executive order is drafted.
And from an enforcement standpoint, does this kind of rule create administrative uncertainty or is there inconsistency across the system, Leon?
I mean, it creates uncertainty, but uncertainty is kind of an understatement, honestly. It creates absolute chaos for something like this to go into effect because, again, there's no legal framework, there's no administrative framework to actually implement what this executive order has been trying to do. And nobody has really sort of articulated one. And importantly, it's not just the federal government that would need to adjust. State and local governments would need to adjust as well.
So turning to you, Wendy, as you mentioned earlier in your introduction, you worked with NAPABA on one of the amicus briefs filed in the Supreme Court. What was the core focus of your brief and what did you want the court to understand that might not be obvious from the parties?
Yeah, so the brief that we filed on behalf of the National Asian Pacific American Bar Association and just under 50 of its affiliated organizations was specifically addressing the story of Wong Kim Ark, and we wanted to address the government's position in the historical and legal context of when Wong Kim Ark was decided, specifically to rebut the government's argument, sort of analogizing Wong Kim Ark's parents to today's legal permanent residents. We went into the historical context of the time when Wong Kim Ark was born. At the time, that was when Chinese migrants were living in the United States, but their legal status and rights as immigrants were very uncertain. This was before the type of immigration laws that we know today. We didn't have work visas or green cards or anything like that. And at the time, there was also a lot of hostility and overt racism and systemic racism, including widespread violence and various laws that were aimed at keeping and pushing these migrants out. So, what we really wanted to showcase in our brief was that beyond the legal arguments, if you take a look at the historical context of Wong Kim Ark and the circumstances under which his parents were living in San Francisco when he was born, it really is not an apt analogy because his parents did not have the types of rights or legal protections or stability that legal permanent residents in the United States enjoy today. To the contrary, they were living in the United States at a time when the permanency of their residence was quite uncertain. At the time that Wong Kim Ark was decided, the social and political factors in play really pushed against the permanency of Wong Kim Ark's parents' domicile. And even within that socio-political context, the Supreme Court in 1898 ruled that the concept of birthright citizenship under the 14th Amendment cannot be limited at the whims of essentially the political influences of the time. So for those reasons, we think this is not an apt analogy. And in fact, if you look at the context of Wong Kim Ark, it actually advocates for the opposite conclusion.
So now in 2026, what do you think is at stake if the court accepts the government's interpretation, even partially?
So I think a lot of the protections that immigrant communities have taken for granted for over 100 years now would definitely be at stake. The concept that you can move to the United States, obtain a visa, or as an asylum seeker or refugee and build a life here and have a family here, that would, of course, all be called into question. There are certainly, like Leon said, a lot of groups that would be disproportionately impacted. And I think it also calls into question a lot of other related concepts that we've sort of taken for granted, and the sense of belonging and who can be a citizen in the United States.
So I want to ask both of you this. During oral argument, did anything stand out about how the justices were framing the case? Where did it seem like they were most focused or concerned?
Sure. No, I mean, I was struck by the fact that there were both wings of the court, the conservative and liberal wing. There were really hard questions being asked about the constitutional foundation of both sides' arguments, but with a particular focus on the government's constitutional arguments and interpretations. But also, and I've probably read a small handful of Supreme Court arguments, a lot of questions about the practical implications of upholding the executive order, and really several of the justices basically scratching their heads as to how are you actually going to implement this, and not necessarily getting the answers they were looking for on that point.
So should the court be considering the implications of enforcing the executive order, or is that not even within the scope of what the judiciary is meant to do?
I think it should be considering it for a couple of reasons. One, it sort of foretells what are going to be complicated sort of due process implications if the executive order goes into effect. In sort of the absence of any sort of meaningful process for even separating out who is subject to the executive order and who is not. So I think it, sort of looking forward, I think that there are those implications. But also in terms of ascertaining what the language in the 14th Amendment means and what the Wong Kim case actually mean, the fact that as a practical matter, that decision and that the 14th Amendment have been implemented a certain way for almost 130 years actually informs what the court's going to decide here pretty significantly. And so I think it's important both in terms of looking backwards as to what was meant at the time that the 14th Amendment was passed, but also looking forward as to the due process implications of how this would actually be implemented.
That makes sense. Wendy, what are your thoughts?
Yeah, I echo Leon's observations. I think the court's questions directed at both the longstanding precedent and the constitutional foundation, as well as the practical implications, suggest that they are giving very serious thought to the gravity of this decision. This is not just a nuanced legal issue. There are very broad-reaching implications, and I think it's a very foundational issue that's being decided.
Okay, so final question, stepping back into Trump v. Barbara, do you think that birthright citizenship, as we understand it today, is legally secure, or is it more fragile than most people realize?
Yeah, absolutely. I think the fragility of any legal right, any constitutional right, is always understated in the public's view until a case like this comes up. At the end of the day, what this case reminds us is that the rights that we've taken for granted for over 100 years really are up to legal interpretations, and that even though we feel like this is established precedent, it may very well turn on a decision.
What I would add to that, one of the things that I've said probably at this point, to the point of boredom to a lot of people, is that if this order were to be applied retroactively, I, the former director of USCIS, would not ever in my life have been a United States citizen because my parents were born overseas. They came to this country as refugees, parolees, asylum seekers, something equivalent to what those statuses are today. And so at the time that I was born, they were not yet citizens or even lawful permanent residents. So basically, I would not be a citizen and I would need to be somehow repatriated to this country that I don't know and that probably does not recognize me any longer as its potential citizen. So I don't know that a lot of people have thought about it that way in terms of how fragile this is. It's being applied prospectively, but there's also no reason why you now couldn't turn around if you were to apply it prospectively to turn around and apply it retrospectively in furthering the potential sort of instability that would result from this executive order. But I don't think that's fully realized by a lot of people.
Thank you both so much. This is clearly one of those cases where doctrine, policy, and lived reality all intersect. Thank you for being here.
Yes, thank you so much. Thank you both for speaking and breaking this down for us.
Thank you for inviting us on. It's an important topic.
Yeah, it's a pleasure to be here.
And thank you to our listeners for joining. Let's brief it. My name is Sade Jai.
And I'm Amanda Hitchez.
And we'll see you next time.
The DC Bar law student community strives to engage and support law students before you graduate and expose you to the tangible benefits of joining the DC Bar and DC Bar communities. Curated programming allows law students to participate in leadership trainings, substantive content programming, networking with practicing attorneys in fields of interest, writing opportunities, and other activities designed to expand your legal education beyond the classroom. Make an investment in your legal career by joining the law student community. To learn more, visit us at www.dcbar.org or email communities@dcbar.org.